Hello and welcome to Topic 3, Lecture 1. And in this lecture, we're going to be talking about gender equality and the United States Constitution. So what are we going to be covering in this lecture? Well, first we're going to talk about the big picture of the role that equality plays in the American political culture. We're going to talk about the 14th Amendment and the Equal Protection Clause. And we're also going to talk about the difference between justified and unjustified differential treatment. So that's what we've got on the docket for today. So let's get started. Equality is a key value of the American political culture. And political culture is defined as the beliefs and values that bind the people together as a nation. I know that some of you are also in my American government class, and we just got done with the discussion of what it means to be an American. And a lot of students, in answering that question, said, what it means to be an American is that we Americans have liberty, that we make decisions in a democratic fashion, and that people are treated equally, both legally and politically, before the law. And so equality is a key value of the American political culture. And it's key and expressed in some of our most important American documents. The quote up there at the top is from the Declaration of Independence. That is the document that outlined what our key values as a nation are, and then made a case for why we need to break ties with Britain. And the famous line there from the Declaration of Independence is, "We hold these truths to be self-evident, that all men are created equal, and that they are endowed by their Creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness." Okay, so right there in one of our most important American documents, the Declaration of Independence, the word equal is front and center. We're also going to see in a little bit that the notion of equality is also front and center in the United States Constitution as well, in particular after the Civil War. But let's keep it real here. We have not, as a nation, always lived up to these ideals. I mean, case in point, that the individual who was the primary writer for the Declaration of Independence, Thomas Jefferson, owned slaves. And in fact, he did not while other founders of America were giving freedom to their slaves, Thomas Jefferson did not. He held on to his slaves for up until his death. And that's just one example of how we haven't always lived up to the ideals. The key word there in the Declaration of Independence is that all men are created equal. And you could look at that and say, well, we can broadly define that word men as human, and there might be some truth to that. But the reality is that different racial groups have been treated differently and unequally in the United States, and women have also experienced unequal treatment in the United States. And so we haven't always lived up to that ideal. I think something to keep in mind, though, is that once you write these words in our founding documents, in the Declaration of Independence and in the amendments within the Constitution, once you write those words down, those words live on, right? And you write them on the page, and then basically that when people try to take away your equality or try to take away your freedom, right, then you can turn to those documents and say, well, wait a second. You promised us these things. You promised us that all men were going to be treated equally, right? And Martin Luther King Jr. in the speech that he made on the March on Washington in the 1960s, his famous "I Have a Dream" speech, he references the promissory note. And what Martin Luther King Jr. says is basically, and I'll just read from the speech, he says, in a sense, we've come to our nation's capital, because they were marching on Washington, D.C. In a sense, we've come to our nation's capital to cash a check. When the architects of our republic wrote the magnificent words of the Constitution and the Declaration of Independence, they were signing a promissory note to which every American was to fall heir to. And, he basically at the March on Washington said that, the American government has fallen short on its promise. That when it came to Negro folks, that African Americans in the United States were given a promissory note, a check, and when they tried to cash that check to say, hey, all people are treated equal, it came up insufficient funds. And so, when you think about it, when you think about the story for the fight for equality on the basis of race and on the basis of sex and on the basis of other categories that people are discriminated upon, that making good on that promissory note, right? The words are there, and that the fight for equality is trying to cash that check with sufficient funds, not insufficient funds. And it really, does become the story of that fight for equality on the basis of race, sex, and other categories as well. Okay, so we see where we find the word equality in the Declaration of Independence. But where do we find the word equality in the Constitution? Well, you don't really ever see the word equality in the Constitution. But there are several amendments that ensure that individuals will be treated equally in the eyes of the law. And so the ones I'm going to focus on in this lecture are the so-called Civil War amendments. And so after the Civil War, 3 amendments were added to our Constitution. And let me just put all 3 of them up there, and then we'll talk about each of these a little bit, and we're going to spend most of our time talking about the 14th Amendment, okay? So following the Civil War, the Constitution was amended to add the 13th, the 14th, and then the 15th Amendment. And you see that they were added at different time periods. Immediately following the Civil War, the 13th Amendment was passed by Congress and ratified by the states. And that is the amendment that abolishes slavery. The thinking is that during the Civil War, we had Lincoln signed the Emancipation Proclamation, but that was only freeing the slaves in the South, in the Confederacy. So, the thinking was, unless we actually amend our Constitution and actually abolish slavery, that coming out of the Civil War, there would be nothing preventing the South from re-enslaving people now that the war was over, or, slavery could continue in the northern states potentially. And so the 13th Amendment abolishes slavery, okay? The 15th Amendment it was passed, it was the last of the Civil War amendments that was ratified in 1870, okay? And that has to do with political equality because it forbids denying the right to vote based on race, okay? Now, we know that even though the 15th Amendment was ratified in 1870, that the actual prohibition against denying people the right to vote based on race did not become a reality until the passage of the Voting Rights Act of 1965. And that we also will learn in our future chapters that it wasn't until the 19th Amendment that African American women and all women got the right to vote, okay? But it is an example of where we find equality, right? Prohibitions on discrimination in our Constitution. For our purposes today, for topic 3, and for this unit, we're going to be focusing on the 14th Amendment. Because the 14th Amendment is really where you get this idea of equality, of equal treatment. So let's take a look at the 14th Amendment. So let's turn our sights to the 14th Amendment that was added to the Constitution in 1868. There are 3 different clauses in the 14th Amendment. There's a lot going on in the 14th Amendment, but let's take a look at 3 of the clauses. We'll touch on these because we'll actually be talking about all 3 of these clauses throughout the course of this semester. And so one clause in the 14th Amendment is known as the Privileges and Immunities Clause. Another clause in the 14th Amendment is known as the Due Process Clause. And another clause in the amendment is known as the Equal Protection Clause, and that's what we're going to be focusing on this week in topic 3, the Equal Protection Clause. So, the main point of the 14th Amendment was to tell states that they couldn't do things after the Civil War, okay? So there was a sense after the Civil War that, we were going to come back together as a nation. The Confederate States were going to join back with the Union, And we wanted to make sure that, Congress wanted to make sure and the states wanted to make sure that there were provisions placed in our Constitution that made sure that states, in particular the Confederate states that were rejoining the Union, to basically tell them that there were things that they couldn't do, okay? And so you'll see, like with each of the clauses, it is the amendment is telling states things that they can't do. So in the Privileges and Immunities Clause, it says, no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. So if you're a citizen, and actually the 14th Amendment gives African Americans, former slaves, citizenship. That's another feature of the 14th Amendment. It's basically saying states can't take away the privileges and immunities of citizens of the United States. And so that is, it basically saying that there are fundamental rights that citizens have, and it restrains the state from taking those things away. Now, as we'll see in a little bit in on the next lecture, what constitutes those privileges and immunities? And are these privileges and immunities sort of targeted at preventing states from taking away things from former slaves? So there's been some controversy around the Privileges and Immunities Clause. It's not really used by the Supreme Court anymore. The other two clauses are used by the Supreme Court. And so the Due Process Clause is saying that nor shall any state deprive any person of life, liberty, or property without the due process of law. Now, there is another due process clause in the Constitution of the United States, and it's in the Fifth Amendment. But the Fifth Amendment is seen as applying just to the national government. So it's basically saying that the national government can't take away a person's life, liberty, or property without the due process of law. But it doesn't speak to whether states can do that, right? Not that, states are non-national, entities. They're state entities. And so the due process clause was added. And what the due process clause is basically saying is that the state and the national government can take away your life, liberty, or property, but they can only do it if they are operating within the law. So they can't take away those things in an illegal manner or in a way that's contrary to law. And also that there must be fair and known procedures in place that need to be followed when taking away your life, liberty, or property. A lot of times when we think about due process, we think about like criminal proceedings, like a jury trial, being told what you're being charged with, etc. But we're going to see that when it comes to fundamental liberties, like the right to privacy, that gives people the right to be free from, that there's places in their bodies that government can't intrude upon, right? You have this right to privacy. We're going to see that the due process clause is used to establish those rights. So a woman's right to contraceptives, or a person's right to contraceptives, and a person's right to an abortion. Okay, so keep that in mind. We're not going to talk about it in this lecture, but we will in future lectures. And then finally, that nor shall any state deny any person within its jurisdiction the equal protection of law. And so that's the Equal Protection Clause. And let's move on to the next slide, because it allows us to define what we mean by equal protection of the law. Okay, so what is equal protection of the law? Well, let's ask Jeeves. No, let's not ask Jeeves. I don't think he'd give a very good answer. I don't even know if Jeeves is working anymore. Instead, let's ask Cornell Law School's Legal Information Institute. And so how do they define equal protection of the law? Well, they say that equal protection of the law means that the government must treat an individual in the same manners as others in similar conditions and circumstances, okay? And so as you're reading these cases this week, you'll see that reference to people who are similarly situated, right? And so here's an example to help us understand that. And so say that you have people who are in similar conditions and circumstances, that they have similar qualifications. So let's say they work at a company, right? And that they have similar qualifications. They have similar experiences with the company, and they've been there the same time. So let's say they have the same level of education. Their work experiences are similar, very similar, and that they've both been at the company for 4 years. But that people with those qualifications, the only people that got promoted were men, and women were not promoted, okay? Well, that would mean that the government's not allowed to do that. If governed by equal protection, that you need to treat people who are similarly situated in the same manner, right? And in this case, it seems as if that is not taking place. Another way that the Legal Information Institute defines equal protection is saying that equal protection forces the government to govern impartially, to not draw distinctions between individuals solely on differences that are irrelevant to legitimate government objectives. And here's an example to think about when equal protection has been violated. So let's say that you have two offenders and they've committed almost identical crimes, okay? And so let's say they're murderers, right? And that they both murdered with, aggravating circumstances, right? And so let's say they both were hired to murder somebody. Let's say that, the amount of suffering that the individual who died was similar in each cases. Let's say that they engaged in, efforts to hide their crime, et cetera, okay? So you got two offenders have committed very similar offenses. Well, you would think that they would get similar sentences, right? That you think that they would both get the death penalty, right? If that's what the state law says or the federal law says, that under these circumstances that this individual would get the death penalty. And that would be, related to a legitimate government objective, that we, don't want murderers on the streets, right? And that the best way to ensure that they'll never be on the streets again is the death penalty. Whether you agree with it or not, you could say that that's related to a legitimate government objective, keeping people safe. But let's say that people who committed those same crimes, that people who are black got the death penalty and people who are white didn't get the death penalty, okay? So you would say that that's a violation of the equal protection of law because you're drawing distinctions between individuals that are on differences that are irrelevant to the legitimate government objective of keeping people safe. Okay, so that's kind of a legalistic take on equal protection of the law, but let's put it into layperson's terms. And so really what equal protection of the law refers to is prohibiting discrimination. In other words, treating people differently without a reasonable justification. It's not reasonable to treat people differently, that the different treatment seems to be like arbitrary or based on stereotypes or not related to the different treatment not being related to any legitimate government purpose, okay? And so, equal protection of the law is basically saying that that laws cannot discriminate in an unjustified manner. The question is how do we know whether when people are treated differently, whether or not that different treatment is legitimate, that there are good reasons to treat people differently, and therefore that different treatment would not violate the Equal Protection Clause, and therefore it would be constitutional? How do we know whether that different treatment is unjustified? That there's no reason that to treat people differently, and if that's the case, then it would violate the Equal Protection Clause, and therefore that dissimilar treatment, that differential treatment, would be unconstitutional. So how do we know whether or not different treatment is allowable or not allowable by the Constitution? And who or what decides whether or not different treatment is actually discrimination and therefore a violation of the Equal Protection Clause? Well, at the end of the day, the entity, the institution that determines whether or not laws violate the Equal Protection Clause is the Supreme Court of the United States. And there's that sort of magnificent picture, right, of and this is for real, right, the glory, the splendor, sort of the majesty of the court. All the cases that you're reading this week, basically are questions about whether or not laws violate the Equal Protection Clause. The Supreme Court is the one who determines that. And as we know from our cases, that the way that the Supreme Court evaluates whether laws violate the Equal Protection Clause changes significantly over time. So some types of differential treatment are assumed to be unconstitutional or unjustified. Racial discrimination is assumed. So when you have laws that treat different racial groups differently, they're assumed to be unconstitutional. And that's because race is considered a suspect class. And what that means is that when you make differences based on race, it's basically making a difference on an immutable characteristic that has no reasonable relationship to being human, right? And so your skin color is something that you can't change. Your eye color, your hair color, right, are things that you can't change. And skin color, eye color, hair color, they have absolutely no reasonable relationship to being human, right? Your eye color, your skin color, your hair color doesn't have anything to do with how smart you are or how, motivated you are or, anything. There's no reasonable relationship. And so when laws make differences based on race, they think those differences, that's a little bit suspect. Also, we have a long history in the United States of discriminatory treatment against certain racial groups, African Americans, Asian, Native Americans, etc. And so that's another reason that when laws discriminate between racial groups, it's another reason why it raises a red flag and why that classification is seen as being sort of a suspect classification. So when there is a law in the books that makes differences between racial groups, these laws receive strict scrutiny from the court. In other words, that the court, when they see these laws, they basically assume that these laws are unconstitutional, and the state has to demonstrate why, in fact, that this different treatment that there's a really good reason for that different treatment. Strict scrutiny is defined as that for a state or the government to engage in differential treatment, treating racial groups differently, that the state must show that it's related to a compelling state interest and that this is the only way that they could achieve this compelling state interest. And I'll give you a concrete example of that in a second. Also, the burden of proof is on the state law. The law has to demonstrate why this treating racial groups differently is related to a compelling state interest. It's not the person who's being discriminated against who has to prove that they don't have to make a case. They don't have to prove anything to the court. It's the state who has to prove. The burden is on the state to prove that this law is in fact constitutional. Okay. Usually, we don't have most laws in the United States that make differences based on race are unconstitutional, right? I mean, poll taxes, the sorts of Jim Crow laws that have, separate, train cars for Black people and white people. I mean, all of those are viewed as having are seen as violating the Equal Protection Clause. But oftentimes strict scrutiny is like, strict in theory, but fatal in fact. So when the court gives a law strict scrutiny, they almost always find that law to be unconstitutional, but not always. Affirmative action is a really good example of where a different treatment based on race is actually allowable. And so, affirmative action is basically policies that are designed to give increased opportunities for groups that have been known to be discriminated against historically, right? And so basically trying to provide better opportunities for groups that have a historic legacy of being discriminated against, okay? And we see affirmative action is used in college applications, right? We can't use quotas. Those are viewed as unconstitutional. But when you are admitting people to college, that you can consider their race, and that the compelling state interest is providing diversity in the college classroom, and it's also seen another compelling interest is to provide a remedy for historic discrimination. And so affirmative action is a good example of a law that deals with a suspect class, right? Different treatment for racial groups, but that in fact that they have demonstrated that there is a compelling interest that the state has, and that this was the only way that they could achieve this compelling interest, diversity, and remedying past racial discriminations. Okay, but generally, when a law is given strict scrutiny based on race, usually that law is found to be unconstitutional, violation of the Equal Protection Clause. So other types of differential treatment are assumed to be justified and therefore constitutional and not a violation of the Equal Protection Clause. A good example of that is treating people differently because of their age. And age, if you have a law that treats age groups differently, in particular treats minors differently than adults, that different treatment is not considered a suspect classification. And that's because one's age has a reasonable relationship to being human, okay? A good example of that is juvenile justice, okay? That I teach a criminal justice class, and that there is a different criminal justice system for those under the age of 18 than there is for the adult criminal justice system, those who are 18 years old and more. So we have laws that treat minors differently than adults when it comes to criminal justice in the United States. And that is reasonable because that younger people have a different capacity to understand the consequences of their actions. Once you're an adult, there's an assumption that you have full capacity, right? That you understand the consequences of your actions, and therefore that when you engage in an action, that there was some intent there to engage in that action. That's not true for people under the age of 18. And in fact, the younger you get, you could say that there's actually no assumption of capacity of understanding their actions. So let me take an extreme example here. Let's say that you have a 2-year-old who picks up a gun, points it at their sibling, and shoots their sibling dead, right? Well, nobody's going to look at that 2-year-old and say, hey, 2-year-old, they knew what they were doing. They picked up that gun and they intentionally shot their brother because they wanted to get that brother out of the picture. Okay, horrible example, right? But it does a really good job. Nobody's going to assume that a 2-year-old has the capacity to understand the consequences of their action. They may not know how a gun works. They might not even know it's a gun. They just don't have that capacity. But it's safe to assume, right, pushing aside some other mitigating factors like mental health, etc., it's safe to assume that an 18-year-old knows that when they pick up a gun and point it at somebody and pull the trigger, that they understand the consequences of their actions. And so it is really reasonable to treat these groups differently. You could say the same thing with treating elderly differently and something like Medicare. You could say, well, wait a second, is it fair to give a policy benefit to those who are 65 years and older? Medicare is basically nationalized universal health care, right? And you could say that's not fair, right? Well, you could say, well, look, that the elderly are likely to be retired. They're not going to have insurance from their job because usually our insurance is connected with employment. And also, as you get older, you're going to have more medical conditions. And so it's reasonable to say that and justified to treat older people differently when it comes to healthcare. Now, laws like this, oftentimes that they receive what's known as the rational basis scrutiny from the court. And so that when you see differences based on age, or you see differences based on income, when you see differences based on like citizenship, that those kinds of differences don't raise a red flag for the court, and they employ what's known as the rational basis scrutiny test. And that, it's oftentimes known as a test where anything goes. Like with the strict scrutiny test, when a law is given that scrutiny, it's usually that law is going to be found to be unconstitutional. When a law that has differences based on age, income, etc., that it's most likely that law is going to be found to be constitutional. And that's because the bar is pretty low. The different treatment must be based in reason, and not just mere hostility to a targeted group. So you can't say, hey, we're going to treat juveniles different because we hate them, or we're not going to treat older people different because they're like, incompetent or something like that. No, But there has to be some reason, right? And we talked about those reasons above. It also has to be related to a legitimate government purpose, right? And so the legitimate government purpose of having a juvenile justice system is that you're so young that it's legitimate to think that that these people are still capable of reform. It's legitimate to provide some social safety nets for people who are older and retired. And unlike strict scrutiny, where the burden is placed on the state to demonstrate that this law is constitutional, with these kinds of different treatment, when you use the rational basis scrutiny, the burden is placed on the individual, and they must prove that the classification advances no reasonable, legitimate government purpose. Okay, so again, it almost assumes that the law is constitutional unless the individual can prove otherwise. So what about different treatment that is based on sex or gender? So when laws treat men and women differently, is sex or gender an immutable characteristic like race that has no reasonable relationship to being human? And so when laws treat males or females differently, or men and women differently, should that raise a red flag? And should say that, like race, this is a suspect classification, and that we should give strict scrutiny to these laws that are treating men and women differently? Or does sex or gender have a reasonable relationship to being human? Sort of like we talked about age, that it's reasonable to think that what it means to be a human is different based on whether you're a young person or an older person. Is the same true with gender? I mean, we do see, particularly when it comes to biological sex, right, that there are significant differences with male and female biology, and in particular, the capacity to get pregnant and have a child. I mean, so, is the different treatment reasonable? Should it be treated like a non-suspect class? And should those laws that treat men and women differently use the rational basis standard when evaluating the constitutionality of those laws? Both? It depends. Neither? Well, the cases that you're going to be reading are going to get us and help us, for lecture 2, will help us understand just how the court should treat laws that differentiate between men and women. As you're going to see as you're reading the cases, that the answer to is different treatment based on gender or sex justified? Is it constitutional? The answer to that question is very important because it defines civil rights policy. Civil rights policy is policy that prohibits discrimination, and it defines law more broadly in the United States. And that as the answer changes as to whether or not the different treatment is justified or constitutional, so does the policy, right? So the Supreme Court will decide, and then the policy will change. Or if the Supreme Court says that law is constitutional, then the law doesn't change. And again, you'll see those in the cases that you're reading for this week. Now, when I taught this class last semester, it was about this time of year that Associate Justice, Supreme Court Justice Ruth Bader Ginsburg had just died. And so as I was, voicing over these PowerPoint slides for this semester, I thought it was still important to, recognize the contribution that Justice Ruth Bader Ginsburg has made to gender equality in the United States. A lot of times we think about Bader Ginsburg as being a justice, but as you're going to read in the cases for this week, prior to becoming a justice, Ruth Bader Ginsburg was a lawyer. She was a litigator, and her career is really defined by challenging laws that discriminated on the basis of sex. Okay, and so as you're reading the cases this week and our understanding of gender equality in the law, we have a great honor and a debt to pay to Justice Ginsburg, because her work has really helped define how we think about gender equality and its relationship to the Equal Protection Clause in the Constitution. Thanks a lot for listening. I know this is some difficult material. If you have questions, please come to Zoom office hours so that we can go through them. Talk to you again soon.